NACDL is the association of the nation's criminal defense bar.
Welcome everyone to today's webinar, Major Changes in the Sentencing of Minors, Recent Legal Updates in the Sentencing of Youth in Virginia. My name is Bonnie Hoffman. I'm the Director of Public Defense for the National Association of Criminal Defense Lawyers, and we're excited to be partnering with Human Rights for Kids and the Legal Aid Justice Center to bring you this very important and timely program. The past decade has witnessed a re-examination of the way our communities respond to youth who are involved in serious crime. Moving away from a lot of the narratives we saw in the 1990s around super predators and the notion that children were incorrigible and irredeemable, advances today in our understanding of adolescent brain development, of the role of trauma, and of the capacity of youth for change have really paved the way for legal and social reforms in the way we treat and punish youth that are involved in our criminal legal system. So building on these new understandings of the needs for developmentally appropriate policies, programs, and punishments, efforts are increasingly becoming centered around the realization that youth should be defined not by the worst thing that they have ever done, but by the potential they possess to be resilient, to grow, and to change. Today's program is going to focus on some recent legislative changes to the Virginia Code, including the changes to 16.2-272, which allows for the sentencing of youth to move beyond a one-size-fits-all approach. So with that, it is my pleasure to introduce Nicola Nabal-Huris, who is with Human Rights for Kids, and she is going to introduce our first speaker.
Thank you so much, Bonnie, and thank you so much, everyone, for joining us for this important presentation today. As we begin, there's going to be polling questions available for you to survey the audience and see what sort of information everyone already is aware of about this important topic and what new areas we're all learning and examining today in this program. I have the pleasure today to introduce James Dold, who is the founder and CEO of Human Rights for Kids. He was inspired to found Human Rights for Kids in May 2017 after his own personal experiences of child sexual abuse and child labor trafficking, and his professional work to end child trafficking and the use of cruel punishments imposed on children who are convicted of serious crimes. He works very diligently to create a national movement of diverse stakeholders from various ideological and political backgrounds to protect the human rights of our most marginalized and vulnerable children. So without further ado, I'd love to introduce to you James Dold.
Thank you so much, Nicola, and thank you to Bonnie and our partners at NACDL, as well as the Legal Aid Justice Center of Virginia for co-sponsoring this event with us. We're really excited to be here to talk about this topic today. It's a really important issue, and it really couldn't come at a more important time as courts and legislatures across the country are grappling with these issues of how do we treat kids who are convicted of some of the most serious crimes when they come into our court systems. And so let me just note at the outset, I also want to thank a couple of really important sponsors of ours, Represent Justice, as well as the Coalition for Public Safety and Arnold Ventures, who have supported our work. And of course, Delegate Vivian Watts, who has championed many of the reforms that we're going to be talking about today. And I'll sing her praises a little bit later on, but she is a titan for children's rights advocacy, and I'm excited that she's able to join us here today. A lot of our work at Human Rights for Kids is informed directly by international human rights standards, particularly those found in the UN Convention on the Rights of the Child, as well as the International Covenant on Civil and Political Rights. We've tried to marry our work in this area with emerging understanding of the impact that adverse childhood experiences and early childhood trauma has on children. For background, 1998 rather, there was a study that was done examining 10 categories of trauma that children experience that had profound impacts on their health later in life. These areas included whether or not a person had experienced child sexual abuse, physical abuse, neglect, whether they had a parent or loved one who had been incarcerated, whether or not they contended with mental health issues in their home. And in subsequent studies that have followed up on the medical impact of children who've experienced these traumas, we've seen that adverse childhood experiences, or ACEs as they're commonly known, have profound ramifications for children throughout the course of their entire lives. In 2014, a DOJ study showed that in the state of Florida, children who had come into contact with the Department of Juvenile Justice there and who had been incarcerated, roughly 90% of them had experienced at least 2 of these adverse childhood experiences, and 48% of boys and nearly 60% of girls had experienced 4 or more of these adverse childhood experiences. They are also more likely than the general population to have experienced early childhood trauma earlier in life. So this was a really important component that wasn't necessarily being taken into consideration when children were coming into contact with the justice system, and was an organizing principle of the beginning of our work here at Human Rights for Kids. I'll also note, when we were founded in 2017, we started off with a board of directors that was made up of 5 Republicans and 3 Democrats from across the country. They came from states as conservative as Arkansas to as liberal as Vermont. And it was against the backdrop of this ideal that we wanted to begin to change the way that the criminal justice system treated kids in a bipartisan fashion, so that people understood the importance of looking at children holistically when they come into contact with the system. Against that backdrop, our journey and conversation really starts back in 1988, when the US Supreme Court began to weigh in on the use of extreme penalties against children in the Eighth Amendment context. In Oklahoma v. Thompson, which is really the first case the court took up under the Eighth Amendment, looking at the death penalty for children, the court struck down the use of the death penalty on children under the age of 16. 17 years later, in Roper v. Simmons, the court struck down the death penalty for 16 and 17-year-olds as well. Central to the majority opinion in that case, that was authored by Justice Kennedy, was this notion that there was this new emerging juvenile brain and behavioral development science that showed that there were fundamental differences between juvenile and adult brains. In particular, the part of the brain that is the executive functioning, the prefrontal cortex, isn't fully developed in children. So they rely on a more primitive part of their brain, known as the amygdala, to make decisions, which in turn then makes them more impetuous, more likely to engage in risky behaviors, and to be more susceptible to peer pressure. This, coupled with the fact that children's personalities aren't as well fixed as adults, led the court in both those cases to find that the penological justifications for imposing the harshest possible punishments on children, in particular incapacitation and retribution, fall away. And really, it's the rehabilitative ideal of the criminal justice system that has to become a primary focus when we're talking about how children are treated for Eighth Amendment purposes and how they're sentenced in adult court. 5 years later, in Granby, Florida, the court for the first time extended this kids are different doctrine to terms of year sentences, where the court held that it was unconstitutional for children convicted of non-homicide crimes to be sentenced to life without parole. And the court in this case likened life without parole to the death penalty, because no matter how much a child changes and no matter how much they grow over time, the child will never leave prison alive. They'll leave prison essentially in a coffin. And so for the court here, it was essential that children convicted of non-homicide crimes have what they termed, quote unquote, a meaningful opportunity to be released based on demonstrated maturity and rehabilitation. And then 2 years later in Miller v. Alabama, the court came down with another decision focused specifically on children who are convicted of homicide-related offenses. Now, in this context, this is an area of much discussion where the court is still developing this area of case law. But there are basically 3 buckets that states kind of fell into and how they interpreted the ruling in the Miller v. Alabama decision. The first bucket of states were states that looked at the Miller decision very narrowly. These states read from that opinion that the court was simply striking down the use of mandatory life without parole sentences for children, but left intact the ability of states to impose life without parole if they otherwise wanted to. Virginia would be a state that fell into this bucket, at least as it was interpreted by the courts initially. The second bucket were states that gave a little bit of a broader construction to the Miller decision. Here, state Supreme Courts in states like Oklahoma, as well as in South Carolina and Ohio, looked at the totality and the principle behind what the court was saying to rule that the use of life without parole sentences on a child without first considering the mitigating qualities of youth, that is, conducting a Miller hearing and determining whether or not a child is irreparably corrupt or beyond rehabilitation, would violate the Eighth Amendment's prohibition on cruel and unusual punishment. The Supreme Court seemingly agreed with this broader construction when it ruled in Montgomery v. Louisiana that the Miller v. Alabama decision was retroactive. In part, we can sort of take from the court in Montgomery that that's in fact what its ruling was, in part because it found that the Miller decision was a substantive rule under the Teague exception, which only finds rules retroactive if a rule categorically prohibits a particular type of punishment on a category of offender, which Miller purported to do, and then the court in Montgomery ruled that it retroactively applied. But going back to Miller for a second, when Miller came down in 2012, there was also another bucket of states, and this is the most interesting bucket of states and one that I'll spend a little bit of time talking about. There was a bucket of states that narrowly focused the scope of the decision on mandatory life without parole, but gave a broad construction to that principle and found that the principles enunciated by the Miller decision weren't just applicable in the context of life without parole sentencing, but rather were applicable in the context of all mandatory minimum sentences for children. So in the years that have passed since Miller first came down, state Supreme Courts in Iowa, Massachusetts, have found under their state constitutions that the imposition of mandatory minimum sentences violates the principle of proportionality and the principle of proportional sentencing, and that the use of mandatory minimum sentences without first considering the mitigating qualities of youth is unconstitutional. More recently, just this year, actually about a month ago, the Supreme Court in the state of Washington, in a case called N. Ray PRP Ali, which is also in the materials that we've handed out, found that their 2017 decision in Houston Sconyers, which found that the use of mandatory sentencing ranges for children violated the Eighth Amendment's principle of proportional sentence under the federal Constitution, and thus was a new substantive rule under the Teague analysis, and applied that new rule retroactively. And so there's about 500 people in the state of Washington now that are being resentenced in line with this new emerging area of jurisprudence. And so as all of this has sort of unfolded in the courts, state legislatures have also kept pace. Specifically in 2016, the District of Columbia City Council passed legislation that ended the application of mandatory minimum sentencing for children there, giving judges complete discretion to impose whatever age-appropriate sentence they deem appropriate when kids come into contact or tried and convicted in the adult system. In 2017, the Nevada State Legislature passed legislation giving judges discretion to depart from mandatory minimum sentences up to 35% away from what they would otherwise be required to impose. And then the Montana legislature had also previously allowed judges to impose or depart from mandatory minimum sentencing. So really, when we step back and look nationally all across the country, as the Supreme Court has weighed in on the extreme punishment of children and the principles that have flowed therefrom, state courts and state legislatures have taken note of this changing area of the law and have really embraced these reforms to say, you know what, we really need to have trauma-informed and age-appropriate accountability measures when children come into conflict with the law. And that applies regardless of the offense that's committed. It applies regardless of the age of the child that we're talking about, because kids are different and they need to be treated differently. And so it was against that backdrop that we began to work with Delegate Vivian Watts earlier this year on House Bill 744, which did away with mandatory minimum sentencing essentially allowing judges to depart from mandatory minimums in appropriate cases. The new legislation, her legislation, also requires judges to consider the impact of adverse childhood experiences, early childhood trauma, and the child's involvement in the child welfare system, as well as considering the differences between children and adults, really looking to what the Supreme Court has said in Miller v. Alabama as a guiding principle for how kids should be treated when they're sentenced in adult court. Now, again, this legislation does not require judges to depart from mandatory minimums, but empowers judges to look at the totality of the circumstances of the child that comes before them, and to craft an age-appropriate and trauma-informed response to the harm that they have caused. And so, this legislation really is in keeping with the emerging jurisprudence that's been developing all across the nation in state Supreme Courts, as well as in state legislatures. And it was against that backdrop that the legislature overwhelmingly supported and passed this new measure into law, which we're going to talk about a little bit more later on today. But before I go too far down that rabbit hole, I did want to flag that we have developed a bench card for judges in the Commonwealth to assist with sentencing kids who are tried and convicted as adults in circuit court that are available in the materials as well as on our website. And I just want to go through a couple of these provisions just real quickly because I think that they're really important for judges and also prosecutors and other criminal justice stakeholders to consider when we're dealing with children who come into conflict with the law, given the backdrop of the Supreme Court's jurisprudence in this area, how state Supreme Courts have interpreted these decisions in this new emerging area, as well as the juvenile brain and behavioral development science and what we know about kids, right? Which is that they have this tremendous capacity to grow and change, and that they shouldn't be deemed throwaway children, and that we should do everything in our power to make sure that we focus on rehabilitating them and successfully reintegrating them back into society. So in our bench card, a couple of things that we highlight is that in any pre-sentence report that is conducted, it's really important that we look at and examine the total number of adverse childhood experiences and the role that those adverse childhood experiences played in the child's involvement in the crime. Details about the ACEs, as well as about the child's involvement in the child welfare system, are also important characteristics and considerations for the court when making these determinations. We also encourage judges to look at how the child's trauma history and ACEs influence their behavior, how the crime might have been related to peer pressure or other youth-related factors like the Supreme Court talked about in the Miller decision, and whether the child has received treatment between the offense and their sentencing that demonstrates whether or not they have this potential for rehabilitation, and thus a departure from a mandatory minimum may be warranted. Some of the guiding questions that we highlight in this bench card are, am I considering the child's age and experiences at the time of the offense? Am I considering the child's trauma history? Is it developmentally appropriate and constitutionally proportional to sentence a child to this particular sentence? How might unintentional biases factor into my decision? And is this sentence that I am crafting for this child, is it age appropriate? Is it trauma informed? And is it in the best interest of the child and in the best interest of society? Right? We are not naive to the reality that there are kids who commit some serious crimes where they're going to need severe consequences in the justice system. But one of the things that we hope people will walk away from this training with is that we don't have to throw those children necessarily to the mercy of some of the harshest possible punishments that otherwise would be required to be imposed under normal circumstances. Indeed, we would submit that whenever a child comes into a circuit court and is no longer subject to just the jurisdiction of juvenile sentencing, that there should be a presumption against the imposition of a mandatory minimum sentence that would otherwise be imposed on an adult. The juvenile's diminished culpability relative to adults should counsel against imposing the harshest possible mandatory minimum sentence, just as the Supreme Courts in Iowa and Washington have similarly found. And so that we hope with these materials and this information, it will be helpful to folks in Virginia who are dealing with these cases when they come into your court. And I'll just say briefly, and we're going to talk about this a little bit later on, the other case that I just wanted to mention is JDB versus North Carolina, another pivotal Supreme Court case where the court created a reasonable child test for determining whether or not a child is in custody for purposes of whether or not they must be read their Miranda rights. Another really important provision that Delegate Watts championed this year was House Bill 746, which now requires that a child's parents be notified when they're arrested and that the child have the opportunity to consult with their parents before they can waive their constitutional rights or be subject to a custodial interrogation. These protections are meant to be put in place to protect the child from unknowingly waiving the rights that are afforded to them, as well as to reinforce the integrity of the legal investigative process, because we know children are susceptible to false confessions, as well as making statements that may or may not be true if they think that it might help them. And so this is really important to, protect the integrity of the process as well as a child's constitutional rights. And so we're going to talk about that a little bit later on. But now I'm going to go ahead and wrap up my remarks, and I am going to go ahead and turn it over to Julie McConnell and introduce her. Julie is, really a force of nature. She is a professor the University of Richmond School of Law. She is also the director of the Children's Defense Clinic at the University of Richmond. In her clinic, she and her students represent on a pro bono basis indigent youth at trial and school-based proceedings and in post-conviction serious offender review hearings. She has worked in juvenile justice for more than 25 years and serves as the co-chair of the Virginia Advisory Committee on Juvenile Delinquency and Prevention and is the chair of the Virginia Bar Association's Commission on the Needs of the Child. Julie, take it away. It's all yours.
Thank you so much, James. I like that, force of nature. I think I'm going to put that on my signature line now, from now on. Thank you for that. It's so wonderful to be with all of you today. And I just want to make sure that I'm clear. We're going to do the polling questions first. Is that, Nicole? Is that correct?
Yes.
Right, so
yes. Before Julie begins, we have 2 polling questions to introduce that we'll be able to see on your screen and we'll be able to answer as Julie begins her presentation. Thank you, Julie.
Okay, terrific. Thank you.
I believe we have the first question. Are law enforcement officers required to notify a parent or guardian before conducting a custodial interrogation of a juvenile? Options are yes, but only if the juvenile is under 16 years old. Yes, anytime the person is under 18 years old. No, law enforcement is under no obligation to notify a parent or guardian before conducting a custodial interrogation, or I don't know. And then just briefly, there's a second question. In what type of cases are transfer hearings required before a juvenile can be tried as an adult? The answers are in all felonies where the juvenile is 14 or 15 years old, only in nonviolent felonies of juveniles 14 and older, in violent felonies when the juvenile is under 18 years old, or I don't know.
So it looks like 77 folks, 34% of you said yes, that we have to note that we have a transfer hearing before a juvenile can be tried as an adult when they are 14 or 15. 18% said only in nonviolent felonies, and 37% said in violent felonies when the juvenile is under 18. Okay. This is somewhat of a trick question because the law has changed, and we're going to talk about that in the next few minutes during my presentation. But the good news is that now we do require a transfer hearing for 14 and 15-year-olds, even in violent felonies. And the second question is, are law enforcement officers required to notify a parent or guardian? Yes, thankfully they are now, thanks to Senator Watts. And we have a requirement that parents be notified. We're still waiting to see how this works out in terms of what requirement there will be beyond notification. Will they have to give the parents an explanation of what's about to happen and allow them to weigh in? All of those details are still to be worked out. But the good news is that the General Assembly did recognize that interrogation is a point in a case that is fraught with danger for juveniles, and recognize that it is important to have parents notified. And I'll just tell you, my bias here is that we even more importantly need to have a lawyer there present before any interrogation occurs. So hopefully that'll be the next piece of legislation that we take up. All right. So we're going to talk about the major changes in laws concerning juveniles this a General Assembly session. There are actually quite a few, and they are somewhat complicated. But I do want to start by reminding everyone that the main purpose of the juvenile court is not just to foster public safety, but also to seek fairness and equity in all cases. This is in the preamble to the Juvenile Code, which one of our guests today, Gerald Jones, helped write when he was a member of the General Assembly and head of the Commission on Youth. And so 16.1-277 is the preamble. In the preamble, the very first point is that diversion should be the primary focus of juvenile court. So not only are juvenile courts the very best place to handle delinquency cases of all kinds, but we should be diverting as many cases as we can completely out of the court system and into the court service unit, where diversionary programs like restorative justice are more applicable. The stats are incredibly high at how many cases are actually eligible for diversion that we don't divert. So we have a lot of work to do here, especially given that it's been very clear since the beginning that diversion should be a primary focus of the juvenile court. As you all know, felonizing our young people really does foreclose many opportunities. They can't get Pell Grants. They often can't get into college. There are many jobs that they're not able to get. Licenses in particular are very challenging with a felony record. Public housing, they can be evicted for a felony. And also they are often suspended or expelled from school. So there are many, many collateral consequences that come with juvenile court involvement, particularly when the delinquency involves a felony. Hopefully all of you know, but I am amazed at how often people don't know that if the young person is 14 years or older at the time of the offense, it will not be expunged automatically from their record when they become an adult. I have to tell my clients' parents that every day, unfortunately. And also, we have a new standard dispositional matrix that the Department of Juvenile Justice has created that they have now sent statewide for all of the court services units to use, as well as juvenile court judges. And so under 16.1-278.8, you'll see all of the options that the court has. And now they will be further guided by the standard dispositional matrix, so that hopefully there's some consistency across jurisdictions with how we respond to juvenile delinquency cases in juvenile court. We have attached that to the materials so that you can reference it. All right, I think it's really important to recognize that we have a huge problem with racial and ethnic disparities in the juvenile justice system. This is just a chart to give you a little bit of a sense of how bad the problem is. The population in Virginia of youth aged 10 to 17 is 54% white and 20% Black, 26% other. At the intake level in the court service unit, 40% of the cases that come in for intake are white individuals, 40% are Black. Remember those numbers, 40% and 40%. Those that actually result in complaints, it goes down to 38% for white children and 43% for Black children. Here's where we start to see even more disparity. At the point at which a judge is deciding, or the court service unit is deciding in initial matters, whether to hold the child pre-trial, 25% of the time white kids get held, 57% African-American children are held at that pre-trial stage. Then when it comes to the petition actually being filed as opposed to handling it through diversion or some other way, 37% of the white kids have a petition and 45% of that same group, remember, only 20% of the population, but 45% of the petitions that are actually being filed in juvenile court. This is statewide. And then on guilty adjudications, of the cases that actually go before the court for a guilty determination on the delinquency, 32% of the guilty findings involve white children, 50% involve African-American children. And here's where we really see even more problems, and that's in the deeper end of the system. Post-dispositional detainments, which is somewhat rare in the juvenile system, 39% of the time it's white, 45% of the children are Black. But here's where we really see the disparity. Commitments. When we're putting kids into the Department of Juvenile Justice, that deepest end of the juvenile justice system, 19% of those kids are white, and 67% of those kids are Black. We have a lot of work to do. So I thought it was important to share this with you. This is from the Department of Juvenile Justice. So this is their statistics that I'm sharing with you today. All right, so there are a lot of changes in the area of trying juveniles as adults or keeping them in the juvenile and domestic relations court. So I'm going to try to go through this relatively quickly, but I have added links to the PowerPoint so you can get right to the statute. Hopefully, this will be shared with you at the end of the session. And hopefully this will be a good resource for you to go back to, because this is a lot of information to digest very quickly. An important thing to understand now is that 14 and 15-year-olds can no longer be automatically certified to circuit court for aggravated malicious wounding or murder. So those of you who practice in juvenile court know that this is the category of kids that used to be automatic certification. So anyone 14 or older charged with aggravated malicious wounding prior to this General Assembly session was automatically sent to adult court after a preliminary hearing in JNDR. Now, under this new law, if a juvenile 16 or older is charged with one of these offenses, then it's the old procedure of a preliminary hearing. If probable cause is found, it goes to circuit court. However, if a juvenile 14 or 15 is in this situation and is charged with one of these offenses, the court may proceed on the motion of the Commonwealth's attorney for a transfer hearing instead. So this is what we would normally have done with non-violent felonies like grand larceny. If the Commonwealth was moving to try your client as an adult, they would have to request transfer, have a transfer hearing before the court. It would be the judge's decision whether to send it to circuit court. The General Assembly has now put these cases of 14 and 15-year-olds charged with aggravated malicious wounding or murder back into the discretion of the juvenile court judge. This is a very significant change. This comes in 16.1-269.1, sections A and B. Happy to answer questions afterward about this, but we've got a lot more to come. So the next one is in 16.1-269.1C. So this is the same code section, but another part of it. The Commonwealth can only file an intent to certify. So these are the intent to certify cases that we used to have for robbery, malicious wounding, rape. If the child is 16 or 17 years old and charged with one of those violent or significant felonies, there has to be a report prepared by the court service unit. The court then provides that to the Commonwealth's attorney and the defense attorney. The Commonwealth's attorney has to review that and consider everything that is laid out in the report and then make a decision about whether to certify. If after reviewing that information, they still intend to certify, then if it's a 16 or 17-year-old, there's only a preliminary hearing. If it's a 14 or 15-year-old, we go back to it's the judge's discretion, okay? This report is something we haven't had before, so it'll be interesting to see how this works out. My assumption that it will be similar to a transfer report. Transfer reports are prepared by the court service unit, and this report that the Commonwealth has to review before seeking certification most likely will be very similar in nature to that. If they decide not to intent to certify, they still can go through the process of doing a transfer hearing and asking the judge to make the decision. So it'll be interesting to see if that actually is something the Commonwealth does, is put it back into the hands of the judge on some of the cases where it's not as obvious to them that they need to try to certify. So these are those ones that used to be codified as intent to certify cases. If it is a 14 or 15-year-old, so again, you have to really look at this carefully because it depends on the age of the child. If it's a 14 or 15-year-old, they get a transfer hearing. On those, what used to be intent to certify cases like robbery, malicious wounding, and rape, those kinds of charges, now they have to do a transfer hearing if they want to request trial as an adult. The traditional transfer case, the grand larceny, the felony drug distribution charges, the nonviolent felonies, if they want to try those individuals as adults and they're 14 or older, it's the same process as we had before. It's a transfer hearing. And then if the judge decides following the statutory requirements of the transfer that it should go to circuit court, then it goes to circuit court. If not, you have a trial in juvenile court. To clarify on this issue of the transfer hearing, I've had to look at this really carefully because so few of us have done transfer hearings in the last few years. Because most of the most serious cases, the discretion was taken out of the juvenile court judge's hands and it was just in the prosecutor's discretion. Now that we have this change back to judicial discretion, we're going to have a lot more transfer situations to consider. So I had to look at this really carefully. To clarify, a probable cause hearing has to occur first. So you're going to have a probable cause hearing just like you would have had in the intent to certify cases. After the probable cause hearing, there will be a second hearing, and that is the transfer hearing. The reason the order has to be that way is it's statutory for one thing, and this is the statute that I've listed here, but also part of the consideration for transfer is probable cause. So to have the probable cause hearing first makes sense because then the judge will know whether there was probable cause. If no probable cause is found, then the next step doesn't occur. You don't have a transfer hearing. The Commonwealth and the defense attorney will have to decide how to handle matters after that. But you can't try it in circuit court if there's no probable cause found. You know, this is a little different from a typical felony where you wouldn't have a probable cause hearing in juvenile court, you just have a trial. So this does create multiple steps. So just to be clear, probable cause hearing, then a transfer hearing. There will be a transfer report prepared by the court service unit. It will be important to really review that with your client. If you're on the defense side, prosecution as well, of course, needs to review that. And then to have testimony to explain what is in the report. I'm going to talk a little bit more in a minute about what will be in the report. These are the findings that the court must make to transfer an individual to circuit court. And of course, our hope, especially given everything you just heard from James, is that this will not be a common occurrence. The juvenile court actually is the best place to handle most of these matters. And so hopefully we're not going to be seeing a lot of these cases go into circuit court in recognition of everything that we've learned about adolescent brain development and trauma. But if you are going to proceed as a prosecutor to try to transfer the young person, these are the things that must be met first. You must give notice to both the juvenile and their guardian. You must have the court find probable cause, as I mentioned, for a felony or a crime that would be a felony if it were charged to an adult. The juvenile has to be competent to stand trial just like in any other case. And there is a presumption of competence. So it is the burden of the defense to raise competence and make sure that that is satisfied by a preponderance of the evidence before moving forward. And then the court has to find by preponderance that the juvenile is not a proper person to remain in the juvenile court. So it's going to be really important to have thorough information about all the things that could happen in the juvenile court system so that the judge can make a decision about whether there are still services that the young person could benefit from in the juvenile system. These are the exact factors that the court must not only review, but they have to actually mark on the transfer form that they have considered each of these factors before the transfer to circuit court would occur. Obviously, the child's age, the seriousness and number of alleged offenses. Can they be retained in the juvenile system long enough? So is it a 14-year-old who could actually, if committed to the Department of Juvenile Justice, stay there until they're 21? That would be a really important factor for the court to think about, because that's obviously a very long sentence for a 14-year-old. The record and prior history of the juvenile in the juvenile legal system. Have they ever absconded from legal custody? And this is not they've run away from home. This is, have they actually absconded from legal custody, which thankfully is pretty rare. If there is intellectual disability or mental illness, it is required that the court consider that. And just remember, this is a little different from a trial where the court would not be able to consider diminished capacity as a defense. But in the transfer hearing, it is very important that any evidence regarding intellectual disability or mental illness be put forth, because it is a key part of the consideration that the court must make in determining whether services are available in the juvenile court system that could assist the young person. So as a defense attorney, I think of this in terms of you are actually able to front load mitigation in your case in these transfer hearings. And in fact, you have a duty to do so because this is essentially along the lines of a sentencing where a judge is going to consider the bigger picture about your client. Adverse childhood experiences, trauma, ruptured attachments, involvement in the child welfare system. All of these things have to be considered along with intellectual disability and mental illness. How do you know whether your child is intellectually disabled or mentally ill? You get their records. And it is absolutely essential that you get their records for these transfer hearings so that you know if there is an individualized education plan or any special education needs that could impact the child's ability to understand the proceedings. For example, if there's a statement, it might be very relevant to whether the child understood he was free to leave or understood Miranda warnings. So you need to get those records, and you also need to get evidence regarding any mental illness or psychiatric treatment. You're entitled to those under your order appointing you as counsel in a case. As a defense attorney in Virginia, you do not have to do a subpoena dicus tecum. You're entitled under the order to get these records expeditiously in a case. So make sure that you are asking for those. In fact, one of the factors the court has to review is the school record and education, but the court is not going to seek out those records. You have to provide them to them. And then the child's mental and emotional maturity. How do you even define that? So you're gonna have to really do some work on thinking about whether you even perhaps need an expert to testify to the child's mental or emotional maturity, because that can be a very difficult thing to determine. And then finally, the 10th factor, the juvenile's physical condition and physical maturity. So the court has to verify that they have considered all of these factors before transfer can occur. And hopefully, and in most cases, they will not see it necessary to transfer these cases to the adult court. Once in circuit court, if in fact they do transfer your young person for trial, I'm sure you all know, but just as a reminder, if the transfer eligible or intent to certify or automatic transfer cases are transferred to circuit court after a preliminary hearing, all of the ancillary charges go as well without any probable cause finding or finding of guilt. They are just automatically sent up to circuit court if they are from the same incident without any sort of findings. So just to be clear on that. Just a reminder that in circuit court, if you're being tried as either an adult or a child, if you appeal your juvenile court conviction to circuit court so that you can get a jury trial, or if you're being tried as an adult and you'd seek a jury trial, the judge sentences you, not the jury. Of course, we've now changed the law in Virginia, and that will be the case in almost every case now, because there will be a presumption that judges will be sentencing rather than juries. But before that change, this was the only time when judges actually sentence rather than juries, and that's in juvenile cases. Under 16.1-272, it is a requirement that the circuit court, consider childhood experiences, adverse childhood experiences. Make sure you understand the ACEs study from both sides of the aisle and as well as from the bench, because it really does help inform a lot of the decisions that we'll be making about kids. The court also has to consider whether the child was ever in a child welfare agency, foster care, were they removed from home? Was there a parent who was incarcerated? Those kinds of serious situations that impact a child's emotional development have to be considered by the court. And finally, the larger concept that juveniles are different from adults. All of the things that Miller, Montgomery, Graham, Roper, and JDB tell us so eloquently must now be considered by the court, thanks to our General Assembly. This acknowledgement of the differences between juveniles and adults is it's a sea change in Virginia law. And so we need to be ready in our sentencing hearings to have a thorough examination of these factors in circuit court. If the child is sentenced to a blended sentence and has a DJJ sentence and then an adult sentence, they do earn earned sentence credits. This comes up a lot. They not only earn them for their time at the Department of Juvenile Justice, they earn them for their time in the detention home pretrial. So make sure you are getting that certification from the detention home to the department so that it goes with the child's record if they ever go to DOC, because that's when this matters, is if they go to DOC. If they go to DOC, they do get credit for that time. So it's very important that we make sure that that record is there for the Department of Corrections to review. This comes up in mandatory minimum sentences as well. Thankfully now, judges have discretion about whether to apply mandatory minimums to juveniles. And there's a presumption that they are not appropriate for juveniles for all of the things that we've talked about so far. Again, quite a significant change in Virginia law. But if you have a child who has previously been sentenced to a mandatory minimum and is serving that now, they will get earned sentence credit towards that mandatory minimum. This is something people often ask. They do get credit for that. And also at their serious offender reviews, the judge can suspend that mandatory minimum time. The General Assembly has told us that that is appropriate in juvenile cases and that we should engage in individualized sentencing that considers all the attributes of youth and trauma history, and that it might be appropriate to suspend those mandatory minimums at serious offender reviews. Finally, just a reminder, if you're tried in adult court on a sex offense, you do have to register on the sex offender registry. In juvenile court, it's at the judge's discretion. Just a reminder, these are some of the ACEs that we're talking about, the adverse childhood experiences that our clients experience and that those who are prosecuting experience. These are this is the data from the Department of Juvenile Justice for fiscal year 2019. 95% of the individuals incarcerated at Bonnier Juvenile Correctional Center are in the community placement program. Community placement programs we have at our detention homes have reported at least one of these ACE factors, and 67% of them have reported 3 or more. So these trauma experiences are having a huge impact on involvement in the juvenile justice system. I know we all know that at this point, but this is a nice illustration of exactly how big the problem is. Just to be clear, if you are in circuit court on one of these felonies, a violent juvenile felony that fits under the serious offender statute, you know, robbery, rape, murder, malicious wounding, aggravated malicious wounding, those types of crimes, the court has 3 options at sentencing. They can sentence the juvenile to serve a portion of the sentence in DJJ as a serious juvenile offender, and then have active or suspended DOC time on top. That's called a blended sentence. They could also sentence the juvenile straight to the Department of Corrections. Hopefully we are doing that never, but it has happened in the past, unfortunately, with very bad results, because young people do not belong in the prison system, in my estimation. And we have done that in some cases, and it's been very detrimental to the health and safety of those young people. But that is an option for the court. They could give an active DOC sentence and then suspend the entire sentence with no juvenile sentence at all. And that does happen in some cases. And that would give the court the opportunity to put the person on adult probation with the supervision that they can provide and time hanging over their head, but no active time. So that's an option as well. And then thirdly, the court can give adult time, but suspend it completely upon the condition that the young person succeeds in the Department of Juvenile Justice under a serious offender commitment. The statutes are here and hyperlinked as well. If the felony that's in circuit court is a non-violent felony, like, again, a grand larceny, the only way a young person can be committed to the Department of Juvenile Justice, if they are not committed as a serious offender that I just described, is as through an indeterminate commitment. And this is in 16.1-285.1. An indeterminate commitment is a commitment in which the Department of Juvenile Justice determines how long the young person should stay in DJJ. Sometimes judges do review these hearings along the way, and they could, decide to recommend that the person be released earlier than the department is suggesting. But typically, courts leave it to the department to determine how long the child should stay. Until a few years ago, Virginia had the longest length of stay in the country on indeterminate commitments, and we found that it was very counterproductive. We were keeping kids longer than they needed to be there, past the point at which they were rehabilitated, and it was causing really serious problems with recidivism rates. And so they did readdress the guidelines that the department uses to determine how long to keep people on indeterminate commitments, and they are significantly lower than they used to be. But the bottom line is, what a child has to do while at DJJ on an indeterminate commitment is they have to satisfy all of the treatment recommendations of the department. They have to complete all of their programs. And until they do that, they're not going to get released. So it is an incentive to kids to do what they need to do while they're there so that they get out sooner. The other option the court could use if they did not do an indeterminate commitment on these nonviolent felonies is they could impose an adult sentence and suspend that complete sentence upon successful completion of whatever could happen in juvenile court. So a juvenile court can't give a child, of course, DOC time. So a juvenile court would only be able to do DJJ or something in the community. So that would be the option the court would have in this scenario. They would suspend the adult time. This is a circuit court sentencing, of course. They would suspend the adult time on the condition that they do whatever conditions a juvenile court might impose, and they would specify what those are. If it's only a misdemeanor, if in the end it's all reduced to a misdemeanor, then the sentencing options for the court are essentially what a juvenile court could do. So they can't give them the 12 months for 12 suspended or anything like that. They can only do what a juvenile court could do. Just a reminder that if you have a young person who was originally sentenced in juvenile court, has aged out and has absconded and finally is picked up when they're 20 years old, and they never have resolved that probation violation from when they were 17 years old, they would go back before the juvenile court as a 20-year-old, and the juvenile court could give them up to 12 months on that violation. If they had more than one offense, they could give them up to a total of 36 months on all of the offenses. That's only for kids that are in juvenile court still that have not been transferred to circuit court. One last reminder, if you go to circuit court and you're adjudicated guilty, you are forever considered an adult, even if you're only 14 years old. Once you're adjudicated guilty in circuit court on an adult case, not just that you appealed, but that you were actively transferred to circuit court, you're forever an adult. So if you get in trouble again, you're automatically going to go to general district court, not JDR, even if you're still a juvenile. Okay, serious offender reviews generally. To serve time in the department, as I said, it has to be either a serious offender commitment or an indeterminate commitment. There is no other option. And so sometimes I've seen judges try to craft a sentence where they basically say, well, it's up to the department. If they want to put them at DJJ, that's fine. That's actually illegal. It has to be a serious offender commitment or an indeterminate commitment, or DJJ cannot take custody of the child. And I'm talking about state DJJ, like Bon Air Juvenile Correctional Center, not your local detention home. A sentencing judge does have the discretion to reduce the sentence at a serious offender review, and that's essentially the whole purpose of the statute, is to consider whether the child has, in fact, succeeded in the rehabilitative programs that were recommended, the treatment programs that were recommended. And if so, the court has the option to reduce the time and now also to suspend the mandatory minimum time. These reviews, in case you've never done one, they occur on the 2-year anniversary of the sentencing date, and then every year thereafter until the child turns 21. And just a note, if you have a young person that you're representing who has already turned 20, and they're going to turn 21 before the next year is up, you can ask the department to petition early and get back in before the court before they turn 21. It's not a hard and fast rule that it be a year. The department always has the discretion to ask for an early review. That can be very important to make sure you have that final opportunity for the court to consider the rehabilitative efforts of your client. Just a reminder, as of 2016, It costs us almost $200,000 a year per child in direct care. So it's very expensive to incarcerate young people at DJJ. As I mentioned, there are studies and lots of research that supports the concept that it is counterproductive to hold young people behind beyond when they have been rehabilitated. And here are two sources that you might want to take a look at. Quickly, a couple more things about serious offender reviews. DJJ petitions for the review. The defense attorney does not. DJJ does. They have to file it 60 days before the 2-year anniversary of the sentencing, and then it has to be held within 30 days of the original sentencing, within the 2-year anniversary of the original sentencing. It occurs in the same court where the original sentencing occurred, whether that's JDR or circuit court. It's the same court. DJJ, as I said, has statutory authority under 16.1-285.1F to file early. This whole process is intended to allow the judge to compare the underlying sentence for the crime that the child committed with their rehabilitation. There are now some very helpful step-down programs in the Department of Juvenile Justice that were funded once we closed Beaumont Juvenile Correctional Center. They include detention reentry and community placement programs that are at a number of our detention homes around the state, and independent or apartment living, among others. These programs can make a huge difference in whether kids succeed. And as a former prosecutor, I find these programs to be absolutely essential. And I do think we should be trying to craft at our serious offender reviews a program in which the child will step down into these treatment programs before release whenever possible. We set them up for a much higher success rate when they have the support of apartment living, when they can learn how to balance a checkbook, when they can learn how to pay rent, when they can learn how to take care of their own place, where they have assistance in finding a job. Because many of these kids, because we have disrupted the attachment so severely by putting them in facilities for years and years, do not have a home to go to. And so these apartment living and independent living programs can make a huge difference. And if you do detention reentry for the first 3 to 6 months, and then apartment living for the second 6 months, so from when they turn 20 until they turn 21, if that's the situation, or when they turn 18 until they turn 19, whenever it is that the court decides that it's appropriate to release the young person, they have this support. And while they're in these programs, they can rebuild their relationships with their families and hopefully succeed at a much higher rate than they would if we just released them from the Department of Corrections a year later with no support. These are the factors the court must consider at a serious offender review. Under 16.1-285.2, they have to review a progress report that is prepared by the department, as well as a risk assessment. These reports will include evaluation of their progress in treatment, how they have evolved in terms of dealing with remorse and the issues involved with the crime itself, their potential for danger to themselves or the community, and an aftercare plan. The department is actually required to develop an aftercare plan, but as defense attorneys, we should be very involved in helping to make sure that that does actually happen. Particularly right now in COVID, there are many challenges to the department being able to do that, so they need our help. The other factors that the court must consider at these review hearings: the experiences and character of the juvenile, the nature of the offenses, the manner in which they were committed, the protection of the community, the recommendations of the department. And not all departments make recommendations. Some localities have a policy against making recommendations, which is really inconsistent with the statute. So we should be asking them to try to make these recommendations whenever possible, because it is important for the court to hear what they think makes sense for next steps for the child. Under the statute, they are required to consider exposure to ACEs, early trauma, or any involvement in the child welfare system. They do have to, again, consider those Miller factors and any other factors the court deems relevant. This is a really important factor. Any other factors the court deems relevant. So they have the option of considering any of the other evidence that you want to bring forward. So it is important to bring that evidence. All right, thank you very much. Let's move on to the panel. So it is my extreme pleasure to introduce to you three esteemed members of the community. Judge Gerald Jones, Circuit Court Judge in Norfolk, was the chair of the Commission on Youth back in the day when he was in the General Assembly and helped write the Virginia Juvenile Code and the transfer statutes that we all work with. He held the line and would not let the General Assembly lower the age beyond 14 when these proposals were originally presented, and we appreciate that very much. He did limit the offenses that were under the intent to certify section as well, hugely helpful. He went on to direct the Department of Juvenile Justice and now is a Circuit Court Judge in Norfolk. Renell Collins Meredith, Deputy Commonwealth's Attorney in Chesterfield in the Juvenile Court and previously in the Richmond Juvenile Court as a prosecutor there for many years. And Brad Lindsay, Deputy Public Defender in Lynchburg, previously in Bedford and Fairfax. So welcome to you all. So wonderful to have you here tonight. All right.
Thank you.
So I have some questions for you. So as you've heard, Virginia law now requires that parents be notified before interrogation occurs. You heard James say that earlier. What are your thoughts about this new policy? Is this a positive or negative? And Renell, would you like to, as a career prosecutor, answer that question first?
I would. And thank you guys for having me and inviting me to be a part of this panel. I actually think it's a good thing that parents will be notified. We often see in cases where children just don't know what's going on. And so they should definitely be given the option to have the parent notified. I think especially when prosecutors get excited, or we like when we see officers doing the right thing and making sure they're not trampling on the rights of juveniles. And so if a parent needs to be notified, it's up to the officer to make sure it's done, unless it's fitting in within one of the exceptions given by the statute. The officer should be attempting to contact that parent. If the officer is not contacting the parent, then they need to be able to articulate why the officer hadn't contacted the parent, what steps they took to try to get in contact with the parent. And then they also need to relay that to the prosecutor handling the case. It's going to be up to the prosecutors to ask the officers about this. We're going to have body cam footage where we can see sometimes where we know the officer has not asked the child about this or has not tried to notify the parent. But we're also going to have to take that extra step to just ask the officer, did you attempt to contact the parent? But I think it's a good thing. I think it helps protect the rights of the children.
Thank you. Judge Jones?
Well, I certainly agree with those remarks, but I also would say that there are going to be some difficult situations because not every parent, will be equal to the next parent. So there are going to be some difficulties, I think, with reaching parents, involving parents in those that kind of an interrogation. I think that is a matter of good police practice. Many departments already do that kind of thing. I think it's a matter of good police practice. My information is that a number of departments actually video interrogations, that kind of thing. And because we know all the issues that surround confessions, false confessions by adults, much less juveniles, and all the things that you've talked about here today, and the reason we have to be concerned that children are not adults, I think it's, anything that we can do to increase the integrity in the interrogation process is absolutely a good thing. As judges, I'm not supposed to render an opinion on public policy matters, but I will step across that line this afternoon and say those things that I just said.
Thank you so much. And Brad?
So I'm going to agree with Judge Jones and Renell that I do believe this is a good first step. I do want to kind of reiterate what you said earlier, Julie, and is kind of my position as well, is I think that we need to be moving towards not only parental notification, but we need to be having attorneys present with children when they are interrogated. What we know about interrogations and what we know specifically about interrogations of children is that they are susceptible to lies, to deceit, to things that would not affect an adult run rampant for children. So what we need to do is continue to design to protect children from false confessions, from trying to go toe-to-toe with a police officer. So I think that the parental notification is certainly
Absolutely. And there's some very high profile cases where parents did exactly that, pretty much forced their kids to confess, which ultimately ended up being false confessions, like Central Park 5 and Brendan Dassey, just to name two. Very significant problems there with the parents. So let's move on to this discretion that is now being given to juvenile court judges to determine who should be tried as an adult. Judge Jones, with your vast experience in this area, what are your thoughts on giving some of this discretion back to judges?
I could not be happier as a judge now for 15 years. I will tell you that judges always need as much discretion as they can possibly have in balancing the scales of justice. Mandatory minimum sentences, which were originally designed to thwart parole, punish, yes, but to thwart parole, I think was the real driving force behind that, have taken that discretion away, no matter what the dynamic factors, the aggravators and the mitigators are in a particular case. So the fact that judges, not only where juveniles are concerned, but even this notion now we're going to have probably more judicial sentencing of adults is just an absolutely wonderful thing. And I can tell you, there have been many, many times I have wanted to do something different with the person who I had the responsibility of sentencing, but I was prevented from doing that, and prevented, quite honestly, what I thought was fairly balancing the scales of justice because of the mandatory minimum. I think it's going to change the culture of the practice of criminal law, juvenile defense, as well as adult defense. And it's going to take a while for us to get there. But I do think there's going to be a culture change in that way. It's going to have to be.
Yes, thank you so much. Brad, what are your thoughts?
I completely agree with Judge Jones. I think whenever you hand discretion back to the court and the court can then take a look at the child in front of it, then that's when we're doing the best work. When we have mandatory transfers, and this should probably not shock anyone, I'm against all types of mandatory transfers for juveniles, then the court can't decide what is best for that child. And if the court sits through and the Commonwealth believes that this child should be treated as an adult, then a discretionary transfer hearing should be a breeze for them because they can prove it through that type of hearing. But to do a mandatory transfer and I just give a quick example, if I have a 16-year-old who pushes a kid down to take his Air Jordans, and then the Commonwealth tells me, well, you either plead as a juvenile to a robbery or I'm going to certify them, then that's a mandatory certification case because they're 16 and it's a robbery charge. And so then I'm stuck in a bind because I have to tell my child that and my child's family that. And the court, I could tell them the court could think your child is the best child there is, but it's just a probable cause hearing at that point. And I think that we have to continue to fight against that and push away from that. We need to go to and keep moving towards, which is exactly what the Virginia legislature is doing, is moving towards this more discretionary transfer, because then the court can decide what is best for that child in front of him or her.
Thank you. Thank you. And Ronell, on this issue of, crafting sentences with the attributes of youth in mind and the trauma history of the young person in mind, giving some discretion back to judges and also not requiring mandatory minimums really opens up some possibilities there in terms of crafting appropriate responses. So can you tell us a little bit about your thoughts on that?
I agree. I think that's a good thing. I think sometimes prosecutors are actually stuck too when we have mandatory sentences, and we don't always want that to be the case. I think a lot of us try to do more blended sentences when we get to circuit court. But I think allowing the court to have discretion will help to to actually be able to work out these cases a little bit more. I think that given the court more discretion is helpful, especially when you're looking at certain people. A lot of times it's judges, some of the different coming before them. They know their history. They know how many times they've been before the court. They can take all of that into consideration when they're trying to make the determination whether or not to transfer a kid to treat him as an adult. So I think it's a good thing to give some of that discretion back to the court. I think that, like I said, I think prosecutors, it gives us a little more leeway in how we handle our cases as well.
So in the past, when you've been trying to determine how to go forward in some of these cases, Ronell, has the question of whether the young person would face a lot of time with the mandatory minimum been a consideration that you've had? It has been, especially when you're looking about years upon years of DOC time. I think that's concerning. And should be to most prosecutors. I know in my practice, I think you mentioned this before, Julie, about sending a kid straight to DOC. That's just not something that I would do. I think that if you have a juvenile, I'm usually looking at some type of blended sentence. So I'm going to send them to DJJ. And then if we have suspended time over their head upon release, or, if they have some DOC time after that, at least they're older when they're going to face their DOC time. But I think it is something that prosecutors take into consideration. I know I have taken that into consideration. And I think, like I said, I think it gives us a little more leeway in how we're handling cases, knowing that, we can still get that conviction for use of a firearm, but, there's no mandatory time that's going to come with that. The court can suspend the time. So I think it helps us with trying to work through our cases as well. Thank you. I'd like to move to the issue of racial and ethnic disparities in the juvenile criminal legal system. And I'd love to hear your thoughts about some steps we could take to address the overrepresentation of minorities at all stages of the juvenile legal system. Judge Jones?
Well, big issue. It's one that we've been grappling with for many years. As you know, Julie, and you and I have worked together on things. And my friend and former legislative colleague, Delegate Watts, of whom I'm so proud, and just want to say I'm so thankful to you, Vivian, all the work that you've done this year and through the years. We obviously, your slide is shocking. One of the things that I did when I was at the Department of Juvenile Justice those years ago was to bring the Casey Foundation into Virginia, in a partnership with Virginia DJJ, and the things that we kind of look at now rather routinely, and the risk assessment and all those things, which were really not the order of the day back then. We brought them into Virginia, and we started doing the Juvenile Detention Alternatives Initiative. And so I am a big believer in assessing on the basis of risk and not race, which is what I said a million times back in those days. I hope we're doing that. I hope we're still making those decisions. I'm not in that juvenile system every day any longer, as you know, but that's a very important thing, that we make those detention decisions, those decision points along the continuum of the juvenile justice system. We have to really focus on making sure that those are risk decisions and not based upon geography or gender or any other, and certainly not race. So, and we also need to be better, I think, about data collection. That's good data you put in tonight, but I think we've got to do better about data collection, not only in the juvenile system, but also in the adult system and sentencing. We really have stopped collecting data by race on the adult side. We've talked about that in our Racial and Equity Commission that the governor appointed me to. So there are a lot of things I think that we just need to be honest about and, kind of step up and recognize that, yes, this is a problem a lot of times that people don't want to be, to talk about. They don't want to be confronted with. But I think that as far as, what we can do in the juvenile and adult criminal justice system, I think we can focus like a laser on risk assessment. And I hope that will make a difference at the end of the day.
Thank you, Judge Jones. Brad?
So I'm finding myself as saying I agree with Judge Jones a lot, but I do. And I think the important thing here is we all clearly see that this is a recognizable problem on a macro level. The data is there, the statistics support this. I think the problem becomes is when we see it on an individual basis, how do we apply that? How do we call it out? And so I think certainly risk, not race, is very important, but it's also very important that these risk instruments are not inherently racist or inherently biased towards race. And so we've got to ask questions about how this data was collected, so we know that we're using the right tools and instruments. And then it's also about protecting our kids, our individual kids. And that comes from better advocacy on the defense bar in that regard, and getting to know your children when you represent them. But more importantly, just making sure that we continue to pass laws that better protect them. We need to make sure that our kids are safe, that they are safe in their persons, their effects, and that they're in their bodies for that matter. So when we do that, I think that's an incredibly important step of providing that young person some dignity that they need to be given back.
Terrific answer, Brad. Renelle.
I think one of the other things we can look at is trying to avoid having people enter the system in the first place. If we start from the beginning and we look at expanding restorative justice, let's do mediation before we even get to court. Oftentimes we see juveniles who are charged with these minor crimes and we're like, why are we even, dealing with this? Couldn't this have been something that was diverted? Expanding the cases that can be diverted. I think if we can start from the beginning and try to limit the number of children who even have to come before the court in the first place, I think that would help with the problem in the long run, quite frankly. I think, like everyone has said, the issue runs deep. It's a big problem. It runs deep. I don't think there's a simple solution to it. But one of the things we can look at is from the beginning.
Absolutely.
And there are some other states. I'm sorry, I didn't mean to.
No, please go ahead.
But there are some other states that are way ahead of Virginia on this.
Mm-hmm.
As I said at a recent meeting that you and I were together at, Julie, Kentucky has moved toward basically kind of a blanket mandatory diversion at the front door of the juvenile justice system there. Not to say the cases don't get through, because lots of cases do get through, but there's this kind of greater commitment to diversion, particularly for the younger children who are coming into the system. We could do much better, even with the existing statutes that we have about diversion, I think.
Absolutely. I think, the primary focus of the juvenile court should be diversion. And there are so many times when we don't divert cases because of really minor problems. The parent didn't respond to the letter from the court service unit saying the case would be diverted. The child didn't do the paper that was required by the court service unit. And so it gets sent to court. And we need to be willing to send those cases back and give people a second chance. So do you think we have an ethical duty as lawyers, as judges, to do everything that we can to reduce racial and ethnic disparities in the system? And whoever would like to answer that first, please jump in.
I agree with Brad.
So yes, we do.
I think
whatever he says, I agree with him. Okay.
Can I write that down, Judge?
Yes.
Does that apply here in Lynchburg too?
Yes, sir. Absolutely.
Thank you. But Julie, I think we do. I think that's how this disparate impact and treatment persists if we stay silent. I think if the attorney, especially from my standpoint, the defense attorney stays silent or doesn't speak up for our children, then no one will. And I think it gets uncomfortable. Like, it's going to be uncomfortable when you call this out in a courtroom, because you're saying that this system in place that has been going on for years is inherently racist or inherently biased, and we have to do something about it. And here is a perfect example, this child right here. So it gets uncomfortable, but I think as advocates, we have to do that.
Thank you. That's an excellent note to turn to. I think we have an audience question we want to try to address before we end. Is that correct?
Sure. We have a few questions from the audience about being able to consider the trauma and experiences that these children have had. Members of the audience have asked how Commonwealth attorneys can best access this information? Is it really through subpoenas, or are there other methods that they can access this information? And similarly for judges, how are they able to gather the necessary information they need to be able to properly consider trauma and adverse childhood experiences?
A lot of court service units are doing ACEs evaluations now. I wouldn't say they're necessarily being done as well as I'd like to see, but we're moving in that direction, and we need to demand that they always be done. We need to ask for experts to help us to navigate understanding our clients' trauma history. We need to do everything we can to ask for more time and more resources. Attorneys need to be paid more effectively. We have the lowest court appointed rate in the country. So, you make $125 to do a juvenile case. It's really hard to do a deep investigation of trauma when you have that little tiny paycheck coming. So we need to work on that. And we need to make all of our courts trauma informed. It should be required, particularly in juvenile and domestic relations court.
Can I make a point on that? I will say everybody would be pleased to know that the OES, the Office of the Executive Secretary of the Supreme Court, which is in Virginia, responsible providing the judicial education, lawyers, CLE, judges, CLE, have at least the last 5 years have built into the curricula in our annual trainings all kinds of trauma-informed judging presentations and educational components, as well as implicit bias. We've had major presenters from all over the place. I'm impressed with the level of attention to that our Supreme Court of Virginia has given to Virginia judges at all levels. I think they're doing that at the bar too, at some of the CLE trainings at the bar, and also with the VACA.
Hey, Julie, can I just add one point to that? So to answer the question, I think someone asked if you had to use a subpoena ducis tecum or something like that. What we do is we have a release of information that we have our child and sometimes the parents sign as well. And then we're out requesting any and all records we can get on the child. So I think that if you can draft that type of release of information, and if anyone needs kind of a template or something like that, I'd be happy to send ours, because this has been very helpful in generating and getting our records. And then that way we can kind of hit the ground running and not having to wait to file a subpoena or something like that. And
you can also use your court order. If you look at 16.1, I think it's 266.1, it's listed at the top of the court order. It specifically says that as a guardian ad litem or a defense attorney, you're entitled to all of these records without a subpoena.
Julie, I know we're running out of time, but I'd like to make one last kind of reaction on my part. All that I've heard today and all the significant, and I agree with you, they are just major changes in the law, all very positive. I think, my takeaway is it's going to create a lot of work for the Commonwealth's attorneys and the public defenders and the private bar attorneys. I mean, there's a lot more that they're going to have to, I think, do now in the context of some of these cases and present to get the kind of information. And I don't think you're going to expect the judiciary to go out on its own to do it. So you're going to have to present it. You're going to have to advocate for it or against it, as the case may be. You're going to have to be really well prepared. I think it's setting a standard of care, quite honestly, that's higher than it has been in the past when it comes to representing children before circuit courts, for sure, in this Commonwealth of Virginia. And that's a good thing. But I just say that's my reaction to all of this. It's a lot to learn. And it's going to be a lot to learn for judges and lawyers.
Hear, hear. And thank you so much, Delegate Watts, for your incredible work to make so much of this possible. We're very grateful.
And I think that, Julie, that's a perfect segue into Delegate Watson. Let me just first start by thanking the panel, Julie, Bonnie, everyone. This has been really wonderful. We're honored to be a part of it. And now it's my distinct pleasure to introduce a good friend and just a fierce champion for children. She really needs no introduction for folks that are familiar in Virginia. She's former Secretary of Transportation and Public Safety, the chair of the Finance Committee, just an incredible, incredible human being. And I'm honored to know you. Delegate Watts, I'm going to go ahead and give it to you to give the last word for everybody that have joined us today. Thank you.
Thank you, James. And of course, I hope I am being heard. I really It's back at you at everything you said, James. You are an absolute inspiration, as well as just being so well informed and really focused in your advocacy. And I also have to thank my good friend, and I miss you, I will say, Judge Jones, and of course the good input from Miss Curtis Meredith, Mr. Lindsay, and Professor McConnell. Very, very inspiring as well as informative, which is why I am so glad that I intended to be on for the entire session. We legislators absolutely need all the help we can get. And I'm so grateful for all the work that each of you have done so that we don't lose the sight of the fact that children in the justice system are treated as children. As my former and again much missed colleague Gerald Jones knows, you can attest to that it's frequently a very interesting journey to sponsor legislation in the General Assembly. No matter how well you think you know the territory, unknown influences and core issues always come in the process of recognizing the challenges and eventually evolving that recognition into new law. Bills may change dramatically from their first version, almost always for the better, as more experts collaborate to make the law as robust and as relevant as possible. I say that because in many ways, how laws grow and change reminds me of the many perspectives I've been privileged to have on the development of children. Youth, especially those who are in the justice system, who receive the proper attention and nurturing and focus, will often transform to be unrecognizable from their former selves. My developmental psychology academic background, my focus on the core physiology of each child I've personally witnessed growing up, and the witnessing the incredible strength that allows many to survive child abuse even at the youngest age, are core reasons why I found it so important for all judges to be challenged, and as Judge Jones said, all who are part of cases to consider the full circumstances of each child in sentencing. Yes, the child tried as adult has been found to have caused serious harm, and it is far too common that the child, however, was strongly shaped to survive the harm they had to endure from trauma and pain of abuse. Only by considering such traumas and now being able to fully consider all alternatives without mandatory minimums will judges truly be able to craft age-appropriate, trauma-informed sentences that treat youth as they are, children, who have the rehabilitative potential to mature beyond their circumstances and mistakes. In my 7 years as the executive director of the CASA program in Fairfax County, I met hundreds of children for whom home was a traumatic place, or home was not a nurturing place. 3 times the number of children are neglected as are physically abused, and yet Justice Department statistics show that they are equally as likely then to be convicted of violent crime as adult if there has not been any intervention. These children often were grappling with experiences that the system couldn't directly or adequately resolve. But in CASA, which exists because of juvenile court judges throughout the nation, could provide them with one person who volunteered to listen to them, believe in them, and advocate and work with all in the system for their best interest. And I know that many in the system are extremely overworked. But I know that after this training, each of you will be better prepared to be an advocate for the children you encounter in the legal system with the added flexibility. By working together, we can ensure that all children, no matter the reasons that brought them to court, are viewed and ultimately sentenced as young minds and resilient spirits with extremely strong core potential, but who need guidance and support to grow into their best selves. While public safety considerations are always a paramount concern, as is the need to ensure justice for victims, we must also remember to balance this with what is in the best interest of the child as being in the best interest of society. As this session has underscored, this will be a complicated task and it won't be easy. But I am very reassured by what I've heard today and the number of participants that logged on to this session of the shared, steadfast belief that there's no such thing as a throwaway child. Thanks so much for your participation in this training, for sharing your expertise, for your intense interest. I look forward to continuing as a legislative partner in this work to ensure that children are sentenced as children in Virginia's justice system. Thank you.
Lily Watts, thank you very much for all that you have done on behalf of the children of the Commonwealth. And thank you to all of our panelists today for being so giving of their time, of their expertise, of their knowledge. I know we didn't get to most of the questions that folks asked. There is so much material to get to here and so much to really be discussed, which is why you should be joining us for the future segments for this program. We are working right now to bring you a program that will focus specifically on adolescent brain development and ACEs. We're going to be looking to do some stakeholder-specific training for folks to focus on some of the defender issues around this, some of the judicial issues, some of the prosecutor issues, to connect with so many of the probation officers that have participated with us here today. You will find on the website for this program, which is on the NACDL website, the link is in the chat, the CLE verification, the CLE form for here. And I'm going to ask if Koichi, our tech guy, can put up the slide one more time with the verification code. You do need the verification code in order to get your CLE credit. You will see that the course number is not on the form yet. We are awaiting that course number from the state bar. So we do need for you to submit it using our form right now with that verification code. The email address is on the form as to where to send the form back. It can all be handled electronically. Again, thank you everybody for attending here today. You will also see, if we can put up the screen for the link to the post-program evaluation. You have all received an email in your inbox also asking you to complete the evaluation. Please make sure to do it. The evaluation really helps us to know what other information you need, how we can better meet the needs that you have, how we can improve our programming, and to give good feedback to our speakers about their presentation so that they can do the best they can for you. So again, thank you to everybody for hanging in there. I know we're running a couple of minutes long, but really appreciative of all of you and of our partners at Human Rights for Kids and the Legal Aid Justice Center. On behalf of the National Association of Criminal Defense Lawyers, thank you to everybody and have a good evening.